Good afternoon, folks. My name is Kurt Hitzemann, County Court Judge here in Hernando County. You folks are here for your first appearance. Purpose of the first appearance is so that you may be informed of the charges against you. I'll determine if probable cause exists for those charges. Probable cause simply means it's more likely than not that a crime has occurred and more likely than not that you're the person who committed that crime. Of course, as you stand before me today, I presume that you're innocent of those allegations. That presumption of innocence will stay with you through every stage of the proceedings, unless and until the state attorney's office is able to prove the allegations against you beyond and to the exclusion of a reasonable doubt. We'll set your conditions of pretrial release today, that is your bail or your bond. In most cases, you've got a bond set already pursuant to the bond schedule here in the 5th Judicial Circuit of the warrant which led to your arrest. I'll determine if that bond should be raised or lowered or left the same, or whether there'll be additional conditions of pretrial release placed upon you. We'll let you know when your next court date will be. If you'd like to have the services of the public defender, I'll gladly appoint the PD to represent you this afternoon. You do have a right to have contact with folks on the outside, family, friends, counsel. If you have not had a chance to make that call, please let me know. We'll make sure that that happens. Finally, and most importantly, your advice that you do have an absolute right to remain silent with regard to the facts which surround your arrest. I encourage you to do that. These proceedings are recorded. In addition, there is an assistant state attorney in the courtroom with me. If you say something that tends to incriminate you, they will use it against you in the prosecution down the road. I now need each and every one of you there at the jail to please raise your right hands and be sworn. Y'all solemnly swear affirm, tell the truth, whole truth, nothing but the truth. Outstanding. When you hear your name called, please step forward to the podium. I have Coey Cole. Afternoon, miss. What's your date of birth?
January 18th, 1987.
This is a probable cause arrest for a violation of probation. There is probable cause for that charge. As to that charge, you wish to represent yourself. You're going to hire a private counsel. Would you like the public defender?
I'd like public defender Derek Saltzman.
Well, I'll appoint the PD. If that's how it's going to work out, that's how it'll work out. The bond, of course, is no bond. I'll have you back in court on the 25th of March, and some attorney will come see you before that, okay?
Okay.
Thank you. Shabrante Crook. Afternoon, miss. What's your date of birth?
December 19th, 1992.
You're here on a warrant signed by Judge Hewitt. She also found probable cause for a violation of probation. As to that charge, you're going to represent yourself. You're going to hire a private counsel. Would you like the public defender?
Yes.
All right, I'll appoint the public defender. Judge Hewitt set your bond at no bond. I can't change that. I'll have you back to see her on the 25th of March. PD will come see you before that, okay?
Judge, the rec is 59 days. She has 30 in as of today.
She has 30?
Yes, she did. She did 28 on the front end.
All right, Ms. Crook, if you wanted to resolve it today, the recommendation is 59. I would sentence you to 60, which is actually a shorter sentence. The public defender tells me you have 30 in. You'd have 20 days left to do. That means your sentence would be done before you would get to court next. Is that something you'd like to do?
Yes.
Very good. You understand by having an admission to a violation of probation, you give up the right to have a trial to the court, the right to confront the witnesses against you, the right to have an attorney represent you, but you want to give up those rights so we can resolve this today?
Yeah.
Very good. Case number 19MM1992, do you admit that you violated your probation?
Yeah, I do.
Accept that admission, find it's freely and voluntarily made, revoke and terminate that probation unsuccessfully, adjudicate you guilty of the underlying charge if that wasn't done before. I'll sentence you to 60 days in the county jail, credit 30 days served. There'll be $100 for the state and your cost of incarceration. But that should take care of it. Shabrante should have 20 days left to do, all right?
And she has restitution and she owes $829.99.
That's still there, yep. All right, very good. Michelle Spence. Afternoon, Ms. Spence. What's your date of birth?
December 10th, 1973.
Michelle, the charge is driving under the influence. There's probable cause for that charge. As to that charge, you wish to represent yourself. You're going to hire a private counsel. Would you like the public defender?
Public defender.
I'll appoint the PD. State what you got.
There's nothing out of Florida, but out of Rhode Island there is a DUI from 2011.
Okay. And Michelle, I have an address for you in Carmel, New Jersey. Is that where you live?
I lived there 2 years ago. I moved here a year ago.
Okay. Where do you live down here?
I live at 5080 Cedar Lane, Brooksville, Florida.
Do you have a job these days?
I do. I'm a server.
Okay. Where do you do that?
Red Robin.
Okay. I'll set your bond at $500. I'll have you back on the 25th of March. Make sure you see the PD when you get out, all right?
Okay.
Thank you.
Thank you.
Michael Marr? Mr. Marr, what's your date of birth?
11/23/68.
All right, Mr. Marr, you're here on a writ to bodily attachment. That means that the child support hearing officer and a circuit judge determined that you owe some child support. They set a cash purge of $677. Do you have that much money, Michael?
Well, I live in Pinellas County. I do have a full-time job. I was homeless all of last year. I'm just getting my life together, and I do have a home and a job.
Okay. Well, those are all interesting things. I want to know if you have $677 in cash that you can get to the jail.
Not on me. I was extradited from Pinellas County. Sir.
Okay. And what do you do for work?
I'm a waiter at Rooster Fish Grill.
Okay. And is there an amount of money, Michael, that you can get to the jail if it meant getting out of jail?
I could have the $677 paid off within 2 weeks.
Okay, I'm talking about today or tomorrow. Can you get somebody to bring money to the jail?
Not from Pinellas County, sir.
Okay. How long you been working that job?
On and off for eight years. I did not work there last year, sir. The child support order that I had was for that job. I just recently started back about a month ago. I was actually surprised they haven't put the order back in to get the child support taken out from that job again.
Okay. I'm going to find that you're in contempt for the failure to pay the child support. Sanction for that contempt is 10 days in the county jail or until you get $50 cash to the jail. $50 gets you out. In either event, when you get out, make sure that you go see the folks at Child Support Enforcement so that you get it cleared up. So, because if you don't do that, this process will start over again and you get arrested again, all right?
Okay, so if I can't get somebody to come all the way up here to pay $50, then
you'll do 10 days. You got it.
Do I get credit for the time I've already had in?
Nope, I just found you in contempt now. Thank you. John Skinner? Afternoon, sir. What's your date of birth?
11/30/1970.
All right, so this is a battery being domestic in nature. There's probable cause for the charge. As to that charge, you want to represent yourself. You want to hire private counsel. Would you like the public defender?
Public defender, please.
I'll appoint the PD. State what you got.
Judge, the only charges we have are our driving charges from 1994 and 1993, a DUI, a reckless driving, and no motor vehicle registration.
Okay. John, I have an address for you on Jody West Drive in Dade City. Is that where you live?
Yes, sir.
How long have you lived there?
Probably about 12 years ago, or maybe more than that.
And Rita lives there as well?
Yes, sir.
Right. Do you have a job these days?
Yes, sir.
What do you do?
I'm a sole provider. I'm a union construction worker.
Okay. All right, so John, I'm going to set the bond at $500. Condition of the bond is that you have, while this charge is pending, you have no contact with Rita. No contact means no contact of any kind. You don't call, you don't write, you don't email, you don't text message. Don't contact her through any social media. Don't go where she lives. Don't go where she works. You don't have any contact of any kind. Any way that you might imagine contacting her, I forbid you to do that. If you have contact and we find out about it, your bond can be revoked and you can be held without bond until the charges are resolved. It means no contact even if she wants to contact. So if you answer your phone and hear her voice, you should hang up If you're out and about and see her, you should turn around and run the other way. You need to understand that she cannot drop the charges against you. That's not a decision she gets to make. She may go to the state attorney's office and ask them to drop the charges. She may tell them she's not interested in pursuing this matter, but that decision belongs solely to the assistant state attorney handling your case. So unless that person or your lawyer or the judge on your case tells you the charges are dropped, you should assume they're not dropped and you should not have contact. In addition, I've got to hold you this afternoon up until 4 p.m. so that if she wanted to serve you with a civil injunction for protection against domestic violence, we'd know where to find you. If you get the civil injunction, it's doubly important that you not have contact, because in that case, not only would you get your bond revoked here, but you'd get new charges for violating the injunction. As far as that address on Jody West is concerned, as long as Rita stays there, you'll have to find somewhere else to stay until we get this case resolved. You can go by one time to collect your things, your clothes, your toothbrush, whatever you need for wherever you plan to stay. But to do that, you must contact the sheriff's office first. They'd meet you there with a deputy who will stand by while you pick up your things and get going where you're going. I'm going to have you back in court on the 25th of March. Very important that you contact the public defender when you get out, all right?
Yes, sir.
Thank you.
Quick
Yep.
question.
Sure, go ahead. John, you don't need to lean into the microphone. In fact, when you do, I can't understand you. So just stand up straight and ask me your question.
How long is that thing for that I can't contact my wife?
Until the case gets resolved.
So like next court date or whatever?
It may get resolved then, but as long as it's not resolved one way or the other, no contact, okay?
Yes, sir.
Very good. Sean Morrow? Afternoon, sir. What's your date of birth?
2/20/1973.
I've got 4 charges this afternoon. I've got a battery being domestic in nature, possession of drug paraphernalia, criminal mischief, and resisting without violence. There's probable cause for those charges. As to those charges, you want to represent yourself. You're going to hire private counsel. Would you like me to appoint the public defender?
I haven't made a decision yet, but for the temporary, I guess the public defender would be
Very
fine.
good. I'll appoint the public defender. State what he got.
Judge, he was just released from DOC on March 4th of 2019. He had been in since October of 2018 for battery second offense. From 2018, there was resisting without violence, a disorderly intoxication, another battery second offense, those being from March of 2018. In 2014, driving on a suspended license. He had been in DOC from June of 2009 through September of 2010. In 2009, he had a battery obstruction and breach of peace.
I got attacked by 5 people and knocked them out.
In 2007, he had a cruelty toward child, a battery.
So that was a punch from the side, and I blocked it.
All right, that's
1996.
that's enough.
Thank you.
Yep. And sir, I don't have an address. Where you been staying lately?
And my mother and stepfathers.
Okay, what's that address?
That's 46 something Pinehurst Drive.
Okay. Do you have a job these days?
Actually, I'm doing work for Knights of Columbus. Plus, I'm also doing some work for this old man that's about sick and dying.
Okay.
I'm cleaning up his house and making sure he has his food, and he's in the hospital right now, taking care of him.
I'll set your bonds on the battery at $2,000, on the paraphernalia at $500, on the criminal mischief and the resisting at $500 each. That's a total of $4,000. Condition of the bond is that you not have any contact with Patrick Doherty. Did you hear me explain no contact earlier?
Yes, sir.
Did you understand
I have a question. I have a question for you, sir.
I'm not done asking mine. Did you understand it when I explained what no contact means?
Yes, sir.
Very good. What's your question?
That's my son, you know.
Yes, I know.
He's 23 years old, right? All I did was smack him.
I don't want you to talk about what you did. You said you had a question.
Father can't punish his child when he's 23 years old, either, huh?
All right. You'll be back in court on the 25th of March.
All right,
We're going to hold you till 4 p.m. Have a seat.
Sorry. Nice day.
Marcus Tillis. Marcus, what's your date of birth?
02/06/2000.
All right, Marcus, you're here on a warrant that was signed by Judge Angelitis for Judge Scaglione. He found probable cause for violation of probation. As to that charge, you want to represent yourself. You're going to hire private counsel. Would you like the public defender?
Public defender at this time, sir.
I'll appoint the PD. Bond on that warrant is no bond. I can't change that. I have you back in court on the 25th of March. Someone from the PD's office will come see you before then, okay?
Yes, sir. Thank you.
Thank you. Larry Whitman. Morning, sir. What's your date of birth?
3/23/81.
Larry, I've got two charges, fleeing to elude and driving on a suspended license. There's probable cause for those charges. As to those charges, you want to represent yourself. You want to hire private counsel. Would you like the public defender?
Public defender, please.
I'll appoint the PD. State.
Judge, he has a pending charge out of Brevard County, a DUI, and a driving on a permanently revoked driver's license. In 2018, he had a flee to elude. And a driving on a suspended license. In 2018, started in 2017, excuse me. He had contributing to the delinquency of a minor, armed trespass upon land of another, permitting a minor to possess a firearm. In 2017, trespass. 2014, he had a violation of probation. That looks like that's from a possession of a controlled substance from 2012. In 2012, he also had a refusal to submit to breath test, a DUI. In 2012, a possession of controlled substance, grand theft. In 2007, a petty theft. 2005, violation of probation. 2004, felony driving on a suspended license.
That's good. Larry, I've got an address for you on Natal Avenue in Brooksville. Is that where you live?
Yeah.
How long have you been there?
My whole life.
You have a job these days?
No, not right now.
Okay. How long has it been since you worked?
On the books for about 3 or 4 years.
Okay. I'll leave your bond at $2,000 on each charge. That's a total of 4. I'll have you back in court March 25th. If you get out, make sure you contact the PD right away, okay?
Yes, sir.
Thank you. Kyle Capobianco. Mr. How you doing?
Good, Judge. How are you?
Good.
Judge, James Matthews, for the record, Mr. Capobianco's parents are also present in the audience.
Okay.
Judge, I filed a motion to set bond for Mr. Capobianco. He was,
I think I did first appearance on him earlier this week.
Yes, Judge.
right.
And I probably revoked on the battery. I think he had a violation of pretrial release.
He did, and it's alleged that he, I think, went to the victim's work and there was a screaming, yelling match of some sorts of witnesses. I am asking Your Honor to release Mr. Capobianco to the PATH, a residential drug and alcohol treatment facility.
Okay.
His parents have secured a bed there for him. They are literally just waiting for him to come, if Your Honor is so inclined to release him there.
Okay,
and make a condition of his bond that he stay there.
Okay. So he's got a bed and they're ready to transport him?
Well, the transportation issue is something I wanted to talk about because I don't think they're set up necessarily to do that. His parents were volunteering to take him, and so it's not a traditional facility where they go. So I'm a little uneducated, I guess, on what how he would physically get there. Again, the parents were of the notion that
does the PATH go get him? Do they come get him?
I don't know the answer. Like I said, it's just that I don't have any reason to believe that is the case, but maybe something could be worked out. But again, the parents' notion was that they would take him from point A to point B. But yeah, like I say, I don't know how to word that.
Okay.
Right.
Okay. State, do you have any feelings one way or the other?
Yes, Judge, we do. We spoke with the victim in this case, and she is obviously still concerned, and she does feel that Mr. Capobianco does have a drug and alcohol problem. So, and that was going to be part of any disposition that we offered, some type of substance abuse evaluation and treatment. I do have some concerns based on what I'm hearing as to how he's going to be transported from point A to point B. He's not really seen fit to show that he's able to follow court orders very easily. We have this new violation of pretrial release that occurred 3 days subsequent. So obviously we would ask that the court maintain a no contact provision, and I would ask that before we set a bond, that something be determined as to how he's going to be transported to this facility.
Okay. Jim, can I talk to his folks?
Sure, absolutely.
You guys want to come on?
Come on up.
Mom and Dad, you want to raise your right hands? Solemnly swear affirm, tell the truth, whole truth, nothing but the truth. Okay. Who wants to be my spokesperson? Okay. I got that situation too. All right. So what's the plan, Mom?
The plan is to pick him up, get him 3 sets of clothes, toothbrush, and take him to the park. Drop him
Okay.
there.
So you're willing to get him from the jail, take him straight to the path.
Yep.
Okay.
You get the clothes ahead of time?
Yeah.
Okay.
Yeah. So then we'll
Okay.
get the clothes.
And how long have you been dealing with these issues with Kyle?
The drug is pretty new,
Okay.
fairly new.
Okay. Are there underlying mental health issues, or is he
I think
self-medicated?
there might be
Okay. How old is Kyle?
24.
Okay. Has he been living at home, or was he out on his own?
No, he's out on his own.
Okay. Okay. All right. Nice. These folks hired you?
They did.
Yeah. Okay. All right. So right now, the case in front of me is 0574. That's the one where he's without bond. He has a set of bond in 594 when I revoked him in 574. And what's your name, ma'am?
Patty?
Patty Copabianco?
Yes.
Okay. So in 574, you still got to post bond on the other one, Jim.
Right. No,
it's not
yeah,
fun.
yeah.
I'll ROR him on this case, but he's only releasable to Patty Capobianco, and only to the extent that she takes him to the path. And then the condition of the bond is that he stays there until such time as the folks at the path would say it makes sense for him to leave.
Right.
Continues to be no contact with the alleged victim in both cases. Okay. So if you guys haven't given up on him yet, I won't. Okay. But understand he's on a short leash now. If he screws up, this is what's going to happen. Back in jail without bond. That's standard operational procedure. I'm sure Mr. Mancuso told you that there was nothing surprising about this. That this is what was going to happen.
Right.
If you guys are willing to get involved and try to get his issues addressed, I'm on board with that. But the second he bails on it in any way, he'll be back in jail without bond. And we'll think twice about that. Okay?
Absolutely.
Okay.
Judge, I have a letter from the path from.
It says that there's a bad.
It says there's a bad.
Jim, you're good. You wouldn't come in here and say that.
No,
It's
no.
true.
It also says it's a long-term facility,
Right.
program.
I've heard it. We've had folks go to it before.
Okay.
Melissa, anything else you want to throw on the record?
I just want to make sure we have the next court date set on both cases.
I think they're both coming back to me, aren't they?
Yeah, they're both your cases.
319.
Yep. They're both coming back March 19th.
Okay.
Yep. They're both on for the 19th for pretrial. You must have filed it. All right. Get all
Okay.
that, Jay? Yes, sir. Anything else?
That's all I have.
Awesome. Thanks,
Thank you.
Thanks, folks. Good luck, kids.
Thank you.
You bet. And then I have Dwayne Barclay.
Judge, Mr. Barclay is before you on 19 MM 3028. It's a resisting without. He had a felony case also. He's been sentenced to 10 months on the felony case. In this particular case, the misdemeanor, he has 68 days time served.
Okay. Dwayne, you want to take time served on the misdemeanor, get this off the table?
Yes, sir.
Very good. Do you understand by entering a plea today, you give up the right to have a trial by jury, the right to confront the witnesses against you, the right to remain silent. You want to give up those rights so we can take care of this today?
Yes, sir.
Case number 19, Amendment 3028, as to the charge of resisting. How do you wish to plead? You can plead no contest.
No contest.
I'll accept that plea, find it was freely and voluntarily made. I'll adjudicate you guilty. Sentence you 60 days, credit 60 days. Fine and court costs is $550, $100 for the public defender's office. I will not order cost of incarceration, as that surely would have been done in circuit court. So that takes care of the misdemeanor, Dwayne. You just got to finish the time on that felony case, all right?
All right, thank
All
you.
right, good luck, you man. Jay, you got anything else for me?
No, sir.
Awesome. Have a good weekend.
Enjoy